And we ended up with 2010 where there was no estate tax. We thought. Because then Congress came along at the end of 2010 and said, no, we're going to reinstate it, and we're just going to give you a new set of rules, which say you have to have over $5 million. So if you're single, you got to go over $5 million. If you're married, you got to go over $10 million before you worry about an estate tax.
And how long is this law going to be in effect?
We've got this one for 2 years. In 2013, this rate's going to jump back up to 55%. And this is going to drop down to $1 million.
And in your best estimate of your knowledge of Congress, what would you guess this is going to happen?
We're not recording this. We all think that we're going to end up with something that's permanent, that's between 3.5 and 5. A couple of statistics for you, as if this isn't boring enough. when this stuff started in 2001, and we were having, the credit protected $675,000, the IRS was getting 250,000 estate tax returns every year. It's where the return basically walks through all of this and ends up down here with your estate tax, what you actually have to pay. So they're getting 250,000 returns. In 2009, when this number had jumped up to 3.5 million, they only expected to get 7,500 returns. So from 250,000 to 7,500. Guess how much revenue it generated though? In 2001, about $25 billion. In 2009, they're expecting $23 billion. So $23 billion off only 7,500 returns. Tells you the tax isn't going to go away, because that's a big amount of income when it really only hits kind of a small number of people across the country. And we live in a place where we're disproportionately hit by this, but I don't think it's going to go away. Nobody thinks it's going to go away. Plus, they've beefed up their estate and gift tax program. They now have 500 attorneys working for the IRS. And they don't have anywhere else to put them. So what they're doing is they're saying every one of these returns that comes in, we're going to audit. We're going to look at, we're going to go through all of these. What was the basis? What was the fair market value? Do you have an appraisal? They're going to pay close attention to it because they've got hundreds of people who don't have anything to do right now. And so they're going to make them audit all these returns.
So that means you do not go to H&R Block to get your estate and gift tax return done, and you want to talk to your successor trustee to make sure they get good advice. This is not the time. If you're in that bracket, please get good professional help, because every single estate around this $5 million area is going to be audited. And they got lots of people to put to work.
To prepare one of these returns, you're probably looking at paying some professionals, an accountant, an attorney who does these types of things, probably 10 grand to prepare the estate tax return.
Is there any other reason to have a living trust besides just taxation?
Absolutely. Because you can see now the estate tax reasons for doing trusts are going away for a lot of people in the country. But when we do these the right way, our beneficiaries get these assets, get them creditor protected. They don't go through a divorce proceeding after...
You mean if you leave your assets in trust to your children?
Right.
How many of you leave your children outright your dollars? Most of you? Some of you? Or do you leave it in trust and name them the trustee of their own children's trust? Okay, good.
Okay, so now that we kind of know how the estate tax works, let's quickly go through what these trusts do. Okay, so we create a family trust. I'm just going to call this the Powell family trust so it's easy for me to, because I have to pick on myself and kill myself in this example. Whether you got to me than to you. So the rules say that we create this trust, we put all our assets into the trust, all the things that we talked about in our gross estate. We put our house, we put our bank accounts, our investment accounts. With some of our life insurance, we make the trust the owner. We do all those kind of things. So the trust gets all my assets. While I'm alive, nobody really cares about this trust because it's what the IRS calls a grantor trust. Basically means I can do anything I want with the income of this trust because these are my assets that I put in there. And that means that all the income is going to get reported on my returns. So there's not a tax return, there's no taxpayer ID number for this. We just kind of put everything in there title-wise so that everything's right there. So that when I do die, this is my side on the, well, there's my P, I'll kill me there. So when I die, the title's already in here. The only thing my successor trustee has to do, who, if you're married, is going to be your spouse probably. If you're not married, you're going to pick somebody. All they've got to do is go to everybody and say, hey, now I'm in charge of this trust. So I can write checks, I can do the investments, I can sell the property. We just need to do the paperwork that shows everybody who's in charge now. That's that trust administration process. That's the first step, is making sure that our successor trustee can take control of these assets.
So if you're a single person, you probably want absolutely to have a living trust because your successor trustee steps right in and takes care of you in the event of any kind of incapacity. It's super protection for a single individual.
Okay, so California is a community property state. The IRS, if you care about this, the IRS is absolutely clueless about what community property means. There are only 8 states out of 50 that have them, and Chuck Morris, who Pete mentioned earlier, is one of my partners in my law firm, who worked for the IRS. He'll tell you right out, they don't even train people anymore on community property rules because there are only 8 states that they get it. So they just give up on this. So we tell them, community property says half of everything is mine, so it's on my side of here, so we have to worry about my estate tax now, right? We have to go through my gross estate, marital deduction, charitable deduction, right? The first thing these trusts do is we know how much I can protect from my credit. Right now that's $5 million, but we know that number is a moving target, right? Okay, so what if my estate's worth more than $5 million? It's not protected with my credit, right? Because this is as much as we can protect. So who can I leave it to without me bringing in estate tax? Spouse, charities, right? So if I leave it to my spouse, let's go over here and look what happened on her side of this. Her assets drop down into what we call a survivor's trust. A lot of attorneys can't stand using all these words, so they call this an A trust and this a B trust. And everybody always jokes, the way to remember that is that she's above ground, I'm below ground. So whatever's her half goes into the survivor's trust. Now, if I have more than $5 million over here, I get to pick. Let's say that I've got another $5 million. Okay, I can leave it to charities, I can leave it to a spouse, if I leave it to anybody else, we're going to have an estate tax on it, right? So my $5 million, my extra $5 million. If I want to, I can create a trust here. This is where you get the C trust. The C trust is a marital deduction trust. It says the only person who's going to benefit from this is my spouse. So when we go back to the gross estate, we've put $5 million, we know we can protect that with my credit. Now we put $5 million, we've used it in the marital deduction, part of that, so my estate's zero for estate tax purposes. Right, so I got to decide. I can put it in a trust for my wife, or I can just put it over here. As long as it goes to something she controls, it's still marital deduction. So how many people have heard about these ABC trusts? Lots of people. Okay. So The C trust is the one you have to think carefully about. Creditor protections and things like that. Let's talk about why you would do a C trust. The assets over here in the survivor's trust. If my spouse runs some attorney off the road and sues her for everything she's got, these assets are completely subject to her creditor's claims. So if she goes to Vegas, goes to Atlantic City, whatever it is, her creditors, debt, gambling, drugs, all those kind of things, these assets are subject to those problems. But everything that's on this half that was mine, I get to say who benefits from them. So I say in here, look, this is a marital deduction trust. The only person who gets to benefit is my wife, my spouse. The IRS has 4 words that they like. They like health, education, maintenance, and support. So health, education, maintenance, and support, those are the 4 things the IRS calls ascertainable standards. Now, nobody knows why they call them that, and nobody knows what that really means, because as far as we can tell, and the tax court tells us this, health means anything you can think of. Elective surgeries, it can mean, you used to read those books where people had to go and spend a summer by the sea to calm their nerves, and things. That's health. Education is very broad. It's college, graduate degrees, all that kind of stuff. It's also the trips up the rivers in France to learn to cook. It's anything that's sort of teaching you new stuff. So education is pretty broad. Maintenance and support, the IRS says, as long as you are living at the same standard of living and supporting yourself at that standard of living, that's maintenance and support. Maintaining your standard of living and supporting yourself at that standard of living. So it's not really hard, is it? I'm not really tying my wife's hands about what she can do, right? She can still go get plastic surgery. She can still go up the rivers in France and learn to cook. She can still maintain herself. And she can do anything she wants, right? So there's really not a whole lot of limits when we use these 4 standards.
What if I wanted to use that money to make a gift to my grandchild?
Okay. You can't do that. Because these trusts, the marital deduction trust, can only benefit the spouse. This credit shelter trust can go to other people. And I could say, use this for the health, education, maintenance, and support of my wife and my kids and my great nephews and my best friend and whoever I wanted to. This one can be very broad.
So on second marriages, I would see that this AB becomes really important.
Exactly, because presumably, if you've got kids from different marriages, let's say, you probably want to track, my half is going to go down here, and I'm going to say exactly who gets the benefit, and it's not going to go to the pool boy or whoever it is that comes along after, right?
It's the cabana boy. So are you saying that somebody should look at an AB trust even though they may not have a $5 million estate?
I would look at an AB trust because it gives you these protections. The spouse is going to have this half of the estate protected from creditors. And if she gets remarried and gets divorced, these assets over here are protected from that process too. I've said the only people who benefit from these assets are the people I've listed, and I list them. So you can do creditor protection, you can do divorce protection, you can do retirement planning, you can do all sorts of things because you know you've got half of the pot set up in a trust that's only going to be used a particular way.
Does this happen automatically and is it free?
I'd get to leave if I said yes, right? That was mine. No, this is the trust administration process. This is, we need to get, when somebody dies, we need to get from, all we had before was this, and now we need to get to this. We need to have the paperwork that identifies who's the trustee of the B trust, who's the trustee of the C trust, who's the trustee of this trust. Which taxpayer ID numbers do we use? What assets are we going to put here, here, or here? We got to go through that process.